Doesn't seem very complicated. It's just a bunch of papers that form the basis of a quiet title action. I'm Darren Findling from quiettitle.com, and I'm going to walk through a quiet title complaint as a template to give you an understanding of how a quiet title action is created, how the lawsuit is built, and how it's filed, and the process relating to a quiet title matter. So here's what happens. The first thing we do is we analyze the title, the chain of title, and we identify any gaps or problems with the chain of title such that we need a court order to terminate or quiet that interest. Those are going to be our defendants in our lawsuit to quiet title. The plaintiff is going to be the party upon which is seeking to clean or perfect its title, the party asking the court to terminate all the interests relating to title that need to be removed. So we begin by building a lawsuit. At the top part of the lawsuit is the plaintiff identified and the defendant or defendants that are identified. We also identify whether those defendants are individuals, and we're asking the court to terminate the interests of their heirs and deficies or assanis, or whether the defendant is a business entity, a corporation, a limited liability company, or an estate. For example, a probate estate or trust. There are various forms of entities that exist, and we identify them in the plaintiff section. The next part of a complaint is that we identify jurisdictionally how this court has jurisdiction over the matter that's proceeding. Most counties, in most courts, the county upon which the property resides is going to be the county upon which the lawsuit is filed. So we would simply identify it. And this is a Michigan lawsuit, a Michigan template of a quiet title action, and we're citing the relevant statute. In this case, it's 600.2932 and MCL 561.7. Further, we're going to identify venue, and venue is slightly different from jurisdiction. Venue relates to the county within the larger court system upon which the cause of action is filed. So in this case, the venue is the county court upon which this complaint to quiet title has been filed. Now we start providing general allegations about the matter upon which we're asking the court to address within the quiet title complaint. We call these general allegations. And in this particular case, we're going to give the legal description of the property upon which we're quieting title. Now, we use a legal description for a very, very particular reason, and that is common addresses like 1234 Main Street can be confusing. Sometimes the address doesn't correspond precisely with the description of the entity. And there are many, many examples of people buying an address or asking in a lawsuit to resolve an address. But we want to be more particular, more specific. And the way you do that is by identifying the legal description upon which that parcel sits and the legal description upon which the court should make its ruling. Then what we do in our lawsuit, after we've identified the parcel that we're asking the court to act on, we recite paragraph by paragraph what we call the chain of title. So we would identify in each paragraph, one at a time, the basis upon which title reads if you go to the chain of title at the Register of Deeds. So in essence, each paragraph in this complaint is going to set forth a separate recording that has occurred at the Register of Deeds. And we generally do those chronologically because it's much easier to read. And we will then identify any gaps in the chain of title. In this particular quiet title action that I have in front of me, this one relates to a tax forfeiture action. We're using the lawsuit to quiet title because of a tax forfeiture that had occurred. But it doesn't have to be that way. It could simply be a gap in the chain of title relating to a missing deed. It could be a land contract in which the seller failed to give a deed to the purchaser. It could be a mortgage that you're asking the court to discharge, and so on and so forth. So you're going to tailor your quiet title lawsuit specifically to the facts of your particular set of circumstances. After we've cited the general allegations within our complaint, and again, this is a Michigan lawsuit, a Michigan complaint, we identify what the problem is. In this particular case, we are identifying that at the Register of Deeds, there are no instruments of record, documents that have been recorded, terminating the interests of the defendants. And further, we're asking the court to make a ruling that the property itself should be vested solely in the plaintiff's name, and that the defendant's interest shall be terminated. This is what we call the prayer for relief. This is the area upon which you're asking the court, while this lawsuit is pending, if the court were to grant all of the relief within this lawsuit, how would that look? What is your ultimate objective relating to the parcel? In this case, we want defendant's interest terminated, wiped out, and we want the plaintiff's interest to hold fee simple title. Now, there's an art in this, as well as, and most importantly, following the statutory requirements. And that's why very few plaintiffs file quiet title actions without the assistance of a competent lawyer. And I can't state this enough. Although this is a complaint, a template of a complaint, we have many, many years of experience identifying how this process works. So we can build these complaints. It's awfully difficult to navigate through a complicated court proceeding without a competent lawyer guiding you each way. The other thing I would say is, even if you get through step one, which is building the lawsuit to clean and correct the chain of title, that's step one of a multi-step process. And even if you were sophisticated enough to file it, knowing what to do next, how to effectuate due process through the service of this lawsuit. What happens when you can't serve somebody? How do you go through an alternate service process? How do the court rules relate to the default of a defendant? How do you handle the hearing? What do you present on the record when you're at that court hearing? And then ultimately, how do you get a judgment such that you could record that judgment to terminate the prior interest? These are complicated issues, very difficult to do without the assistance of good counsel. If you've got questions regarding quiet title actions or interested in some of the information I've set forth in this quiet title template, you're welcome to call me, 877-YOUR-FIRM, or visit us at www.quiettitle.com.